please switch on your video so that we can then start the session and the proceedings for the day.
So should I start with the...
So one second, I'll just introduce the program and we can do it. Yeah. So good evening, ladies and gentlemen. Welcome everyone to the celebration of the International Human Rights Day today on December 10, 2020, which is being organized by Chevening Alumni India in collaboration with the Nirmal and Kapila Hingorani Foundation and the Virtual Law School. I'm Nachiketa Mittal, your moderator for the session today, and I would very briefly mention to you before I request Mr. Tarun Singhal to welcome all our guests for the day that Chevening is UK government's global scholarship program to offer future leaders the unique opportunity to study in the United Kingdom. And Chevening India Alumni, which is led by Senior Counsel Priya Hingorani, is today putting this entire program together for all scholars of law and social science and everybody who is a stakeholder in the broader discourse of international human rights to celebrate this occasion. And I, as a law professor, also welcome you on board. And to tell you, my dear friends, this program is being held in association with Kapila and Nirmal Hingorani Foundation. And most of you may know, but perhaps it's my duty to put it through across on board for everybody in the panelists, also in the audience, to know that Pushpa Kapila Hingorani and Sri Nirmal Hingorani were the leading lawyers of the Indian Supreme Court who have left fine imprints and created jurisprudence in the field of public interest litigation at large. They are the partnering organization with Chevening Alumni India. And I, as a law professor and a founder of the Virtual Law School, which is the law teaching platform in India, together are supporting Chevening India in this entire event. Now, on that note, I request Mr. Tarun Singhal to introduce our guest for the day. And Mr. Tarun Singhal is the General Secretary of Chevening Alumni India. Over to you, Mr. Singhal.
Okay. So thank you so much, Nachiketa. Just to stand corrected, the General Secretary is Dr. Shuchin Bajaj, who would be introducing the panel very soon. But I'm here to welcome everybody and give a short intro. So very good evening, everyone. Once again, I'm Tarun Singhal, and I'm the Vice President of the Chevening Alumni India and the Director for Business Development and Marcom with Sopra Steria and Sopra Banking Software in India. I welcome you all at this such an important occasion of International Human Rights Day. Human Rights Day is celebrated annually across the world this date, which is 10th December every year. The date, for some of you who are not aware, was chosen to honor the United Nations General Assembly's adoption and proclamation on 10th December 1948 of the Universal Declaration of Human Rights, UDHR, the first global enunciation of human rights and one of the first major achievements of the new United Nations. Actually, this year, with more of virtual connect, this topic required a different enhanced perspective, which I'm sure we will gather insights from the esteemed panel today. As we all know, India is a country full of heritage, culture, and colors. And here we all call our Chevening and British scholars as rising and guiding living bridge stars of India. Chevening scholarships, as Nachiketa mentioned, are awarded to outstanding professionals from all over the world to pursue a one-year master's degree in any subject at any UK university. Chevening Alumni in India was formed in 2015 with an objective of bringing together the Chevening alumni in the country. Today, we are over 3,200 scholars and still growing. This makes us one of the largest alumni globally of Cheveners in a country. As an evolving association, we also aim to contribute to the betterment of the society with focus on trade, culture, sustainability, mental well-being, cyber wellness, and corporate social responsibility. Today, here in this panel, we have amongst august gathering of esteemed speakers and industry professionals attending this webinar. Two esteemed British and academic scholars also speaking here today are Honorable Justice Sanjeev Sachdeva ji and Miss Priya Hingorani ji, Senior Advocate, Supreme Court of India. With this, I hand over to Dr. Suchin Bajaj, General Secretary, Chevening Alumni, introduce all the global speakers. Thank you and enjoy the session. Thank you.
Thank you very much, Tarunji, for that rousing introduction and welcome. I agree with you. It's a very important day today, and we are really lucky to have amongst us such a illuminated and illustrious panel of speakers with us today to talk to us. We have the chief guest today, Honorable Mr. Justice Sanjeev Sachdeva. Justice Sachdeva has been an alumnus of Delhi Public School, Mathura Road, and Sri Ram College of Commerce, New Delhi. He did his Bachelor of Law degree in 1988 from Campus Law Center, University of Delhi, and was enrolled as an advocate with the Bar Council of Delhi on 1st of August 1988. Justice Sachdeva was awarded the Foreign Office Scholarship by the British government to attend the Commonwealth Young Lawyers course at Institute of Advanced Legal Studies at London in 1992, one of the only 5 such lawyers selected from across the country. He has also been the founder secretary of the Association of British Scholars in India and also been its vice president for 2 terms. Justice Sachdeva has been qualified as an advocate on record for the Supreme Court of India in June 1995 and has been a justice with the High Court of Delhi since April 2013. Joining him, we are very lucky to have Ms. Jyotika Kalra, member National Human Rights Commission. As per her protocol as a member of the NHRC, she is equivalent to a sitting Supreme Court justice. She has been practicing advocate and advocate on record with the Honorable Supreme Court of India, did her Bachelor of Commerce from Delhi University and Bachelor of Law from Campus Law Center, Delhi University. She has been instrumental in filing many public interest litigations. Significant among them is opening up a channel for females to practice as makeup artists in the cine industry after 60 years of independence, and raising the issue of non-recruitment of women in the armed forces that resulted in opening of opportunities for women in the territorial army. She has also been dealing with subjects like women, children, LGBTI trafficking, reproductive rights, etc. as a member of the NHRC. She has been honored by the Supreme Court of India for her 3 books and was also given the award of Outstanding Women in 2014 by the National Commission for Women. She is a passionate activist and has been associated with many NGOs, and in the past she has also been a part-time lecturer in the Faculty of Law, University of Delhi, and IP College, Delhi University. We are also very honored to have with us today as a speaker, as a keynote speaker, Mr. Brian Spears. He is the president of the Commonwealth Lawyers Association, one of the most premier lawyers associations in the world, and is also a senior partner with CMG Cunningham Dickey Solicitors. He is an experienced commercial mediator, conflict resolution trainer, supporter of the rule of law, active participant in legal issues affecting the Commonwealth of Nations. He is also a legal expert in housing and property development and planning, and a legal vocational trainer. We have with us Beth Yates, First Secretary Political Affairs at the British Deputy High Commission, Mumbai. Unfortunately, we can't see her on video yet, but I hope we will be able to see her very quickly. She is an experienced government official with a demonstrated background working on public policy, strategy, and delivery. She is skilled in relationship management, strategy development, and operational delivery. She is also a polyglot with university level Spanish and Portuguese, intermediate Hindi, and basic Catalan as her speaking languages. We also have with us Ms. Priya Hingorani. She is a senior advocate and representing both the Kapila and Nirmal Hingorani Foundation, as well as being the president of the Chevening Alumni Association, the main body that is organizing this seminar today. She has also completed her Bachelor in Law from Faculty of Law, University of Delhi, and has been a Commonwealth Young Lawyers Association course studied in the UK. She has been active in law practice since the year 1990, as when she was enrolled as an advocate with the Bar Council of Delhi. She's been practicing in the Supreme Court of India as well as high courts across the country and subordinate courts as well. And to round off our illustrious speaking list, we have Dr. Nachiketa Mittal with us. He's the founder and director of India's first virtual law school and has been in the past serving as Dean in charge of United World School of Law, Karnavati University, Gandhinagar as well. He is also formerly a faculty of law in the National Law University, Odisha. So welcome to all speakers, and I hope we have a wonderful discussion. Over to you again, Nachiketa.
Right. Thank you so much, for a very detailed introduction of all the speakers, Dr. Sachin. And now I request our next speaker for the program is Jyotika Kalra, member, National Human Rights Commission, to kindly address us on the International Human Rights Day. And ma'am, we are looking forward to your perspective and thoughts. Over to you. Ma'am, you may need to unmute yourself.
So thank you, Nachiketa. I'll start without any formal thing. So this is a International Human Rights Day and we are all celebrating. And it is because of the Universal Declaration of Human Rights, which was proclaimed by the United Nations General Assembly in Paris on 10th of December 1948. As a common standard of achievements for all people and all nations. I'll take two paragraphs from the preamble, I think, that serve the purpose. And the first para is that whereas the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And the second para, which I think is very important, is which mentions about whereas it is essential, if a man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. So the onus is upon the rule of law to ensure that the human rights are protected and people are not compelled to have rebels, people are not compelled to take other recourses as a last resort. And I'll now come to the Article 1, which I think is the gamut of the entire discourse of human rights, which Article 1 says that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. So important it is. It's not only free, equal, in dignity, but it also says that every human being is endowed with reason and conscience, and we must act towards each other, one another, in the spirit of brotherhood. This Article 1, as I said, it's covered the entire gamut of the human rights. And I'll quote Antonio Guterres, the 9th Secretary General of United Nations, and I quote, Hansa Mehta of India, for example, and I was discussing with Priya also about that, and she said, our first initial talk, I talked about this, I mentioned this, and she said, okay, when you will speak, please mention this, do include this. So I quote, Hansa Mehta of India, for example, without whom we would likely to be speaking of the Universal Declaration of Rights of Men rather than of human beings. So Mehta, a reformer, educator, and a prolific writer, she served as the Indian delegate to the United Commissions on Human Rights from 1947 to 1948. She is widely credited with making a significant change in the language of Article 1 of the UDHR by replacing the phrase all men are born free and equal to all human beings are born free and equal. If Hansa Mehta would not have been there, so rather than talking about the human rights of human beings, we would have been talking about the human rights of all men. So this declaration was adopted before our country adopted its constitution on 26th of November 1949, and we can see that chapter 3 of our constitution of my point is that once equality and dignity is ensured to all human beings, the rights will become a reality and the struggle would be over. I want to say, I mean, the aspiration which we have that we are all equal in dignity and it is inalienable, if it is ensured, this struggle of ensuring that rights become a reality will be over. The struggle would be over. It's being said that human right is a negative right. It is why I say negative right. It is because it comes into fray only when it is being violated. The name of the act is also Protection of Human Rights Act. That means only when there's a violation, the law comes into the picture, or this law is the human right concept is being realized. And basically, the public servants who are held responsible for violation of human rights, our act also only encompasses the action or non-action by the state through its public servants. So the different types of, broadly, the human right violations are in the form of misgovernance, in the form of social cultural practices like witch hunting, etc., environmental issues, misgovernance, also the medical negligence or at the hospitals, police atrocities like custodial torture, fake encounter, death in prisons or prisons, health conditions of women subjected to the sexual violence, etc. All this I just broadly said because we are all from the legal background, so there is no need to give the examples of violations of human rights. But yes, there is a need to discuss what are the challenges to the protection of human rights. The challenge, the first, why are we struggling yet to ensure that these rights become a reality? The challenges are poverty. The challenges of poverty, like the defecation in open, the manual scavenging, child labor, child marriage, it's all because of poverty. Women being considered as a weaker sex, that is another challenge to realization of human rights. Sexual violence against women, domestic violence against women, discrimination, gender stereotypes. So this, and then the challenge of inequality, or we may call it as a majoritarian culture. This inequality in form of economic inequalities, religious inequalities, linguistic inequalities, ethnic, racial, gender, social class, and other inequalities. And then the challenges of group at risk, distress, and this is like exclusion of those with HIV, exclusion from the mainstream of the persons suffering with HIV/AIDS, homosexuals, transgenders, persons with disability, etc. And we have good judgments from the Supreme Court on transgenders, or on this Navtesh Singh Johar on 377. And we have recently had the acts also on the rights of the transgender and on the rights of persons with disability. So those challenges have been taken care of by the legislature we have. I think the most serious challenge to the realization of human rights is the lack of education. Lack of education, when I say it, is lack of quality education. Though people are educated, but they are not in a position to access to the information on the strength of their education. They are not in a position to access to the resources meant for them on the strength of the education. So we need to have an aware citizenry which can challenge, which can question the functioning of the state and ensure that they get their dues, to which they are entitled for. And universal quality education is also one of the declaration. But I think in India, when we have that education as a fundamental right, we must include adult education, because most of our population, which is adult and which is uneducated, we must include them also for mainstreaming them and making them capable of realizing their rights. And at the last, not at the last, but then there's this challenge of new threats. This is in the form of terrorism. So that's also a major threat to the realization of human rights. And we can see this in J&K and other places, extremism and terrorism is also it also deprives the people from realizing their human rights. And last, which I quoted in the preamble also, the last challenge to human right is, there can be others, but in my deliverance, the challenge of rule of law. We are not in a position to have an effective and a strong and efficacious system of rule of law, which results in poor investigation, poor conviction rate, and poor observation of procedural safeguard. And I must say that the history of personal liberty is largely the history of insistence on observation of procedural safeguards. So the procedural safeguards observed means that personal liberty is observed. And in most of these human rights violations, the poor and the marginalized are pitched against the strong and powerful state. And these victims can't withstand that powerful state. So there comes the role of human rights institutions. And it includes in itself the National Human Rights Commission. And they are under obligation to question the state as and when a complaint comes about violation of human rights. And I conclude by quoting Antonio Guterres at the end, and I quote, "Lasting peace and inclusive sustainable development can never be achieved without full respect for human rights." On this anniversary, let us not only reflect on the enduring importance of the Universal Declaration of Human Rights, let us also speak out and stand up for human rights everywhere. Thank you very much.
Thank you very much, Ms. Kalra, for your thought-provoking message on the International Human Rights Day. And I think one of the very important takeaways is about the strength of education that you have highlighted, especially about the universal quality education, which would certainly help in the true realization of the constitutional rights for one and all at par. So we take this session forward, my dear friends, ladies and gentlemen. And today, now we are glad, Ms. Yates, that you are able to log in. So welcome you on board as a panelist. And so now you are going to speak on this occasion as the speaker for the day. And to tell all the friends in the audience, Ms. Beth Yates is First Secretary, British Deputy High Commission from Mumbai. And we're looking forward to your thoughts on the International Human Rights Day. Thank you. Over to you.
Thank you. I hope you can hear me okay, and thanks for your technical expertise in the end. Fantastic. Thank you so much. So yeah, my name's Beth. I'm here in Mumbai currently, and I'm really glad to be here today to talk to all of you. So in my role as First Secretary, part of that involves human rights programs and policy work in the west of India. So that primarily covers Maharashtra, Madhya Pradesh and Goa, but I work with colleagues across India. So today I'll be talking to you about some of the work that we have been focusing on across India, all with partners, of course, here in India. And I may well have met some of you at previous events and during visits. So if I have, then a big hello to everyone. So I'll go through a few examples of some of the work that we've been doing across the country with partners. And then at the end, I'll just take any questions or suggestions for how we might want to collaborate more going forward into 2021, which hopefully will be a little bit more of a steady year in terms of the kind of program and policy work that we normally do. So I hope that sounds okay. So in terms of the kind of priority issues that we work on here in India, there are 4 issues that we primarily look at. The first one is human trafficking. The second is gender equality. The third is freedom of religion or belief. And the fourth is LGBT rights. Now, the main point across all of these is that we work with Indian partners across everything. And that includes civil society, government organizations, grassroots, NGOs, etc. And that's very, very important to us as a concept. I'm sorry, I just think, is someone off mute? I can hear a bit of feedback.
We're good. We can hear you.
You're all right. That's fine. Okay.
Yeah.
So yeah, it's really important for us across all of these that we work with partners in India to do any programs or engagement. And that's the first thing to say. So I'll just give a few examples of initiatives we've done the past year, which has been a bit of an extraordinary year, of course, but the kind of demand hasn't been any less great. So on human trafficking, we're working with a number of authorities to build institutional capacity primarily to deal with cases of human trafficking and forced labour. And that's directed at tackling root causes and drivers, so through education, livelihood and social protection programmes primarily. So just one example of some statistics that might put things into a bit of perspective. So this year, over 7,500 families benefited from community-based awareness programmes that we supported in Chhattisgarh, Assam and West Bengal. And one other statistic that I can't take credit for, I wasn't involved in this programme directly, but a fantastic result in Uttar Pradesh, where over 8,000 young people re-enrolled in government schools partly through these community-based programmes. So I think that's really, really good to hear. On gender equality, there's recently been a pledge for progress that we've launched in India, which is a joint commitment between the British High Commission and over 120 Indian partners. And that's aimed at promoting gender equality and taking practical steps to tackle gender challenges. And that, you know, some of those organisations are really big corporates. So that's a fantastic joint initiative that we've taken forward this year. And we're also working closely with some British businesses in India to tackle sexual harassment in the garment sector. And that's reached over 33,000 workers so far. So there are a couple of examples on gender equality. The third issue is a freedom of religion or belief. So in May, which was, you know, mid-pandemic, we held a virtual iftar, and we were joined by over 100 participants from across India, with media coverage reaching around 7 million people. And that was a great event headed by our High Commissioner, Jan Thompson. And this year, we're working on a project to build a network of 15 emerging faith leaders in India. And that's aimed at promoting values of tolerance and multiculturalism and supporting meet the challenges of leading inclusive modern faith communities. And finally, an issue that I lead on across here is LGBT+ rights. And there's been a lot of activity this year with some fantastic partners. But I'll just mention a couple of things. So for the second anniversary of the Section 377 that you'll all be aware of in September, we had hundreds of people join 8 events run from 7 locations. And they included policy workshops, film screenings and interviews with prominent. And we also flew the rainbow flag in Delhi for the first time at the British Council, which was great. And then just a couple of weeks ago for Trans Awareness Week, we held a panel discussion with trans lawyers and activists to discuss trans rights in legislation. Sessions will inform our programme development next year. So just a few examples of what we've been doing, and I hope that just gives a flavour of the work that we're focused on, but also here, please do get in touch anytime. And thank you so much for giving me the opportunity to speak today. I can take any questions if there's time.
Yeah, thank you, Ms. Yates. So what we propose is a Q&A session at the end once all the speakers, would complete their speech for the day. So is that all right?
Hello? Absolutely.
Yeah. So Ms. Yates, I'm suggesting that we'll take Q&A a little later after 2 more speakers were there to share their thoughts for the day. Is that all right?
Yeah, absolutely.
Yeah, perfect. Yeah. Great. Okay. So thank you for outlining your entire project and different kinds of initiatives being taken across the country, and especially in the western part of India. And you've touched upon some of the very important issues. And we as the Indian Republic have contributed in that sense a lot for, as everybody knows on board, in last 4 to 5 years, Indian Supreme Court has, changed the entire discourse of human rights. And there's been so many leading progressive judgments, from the third gender judgment to Navtej Johar judgment, and also the right to privacy and so on and so forth. So taking the same forward, now I request Mr. Brian Spears, who is president of Commonwealth Lawyers Association from the UK, to share his thoughts, on behalf of the legal fraternity, and being members, we all of the larger, practice of law as law professors and, judges and lawyers together. We look forward to your thoughts, sir.
Thank you very much, and thank you for the kind invitation to speak. I am bringing you a different accent than the accent that Beth has contributed from another part of the UK. This accent is from Belfast, Northern Ireland, which, if you are following the Brexit debates, you will know that Northern Ireland has thrown up all sorts of complications, being part of a geographical island, the most of which remains in the EU and has no land border separating the two parts of the island. And we all continue to watch with interest the progress or lack of progress in the current Brexit talks. But it's a great honour to speak to you all on Human Rights Day. And let me first of all bring greetings from the Commonwealth Lawyers Association. The CLA represents lawyers in all 54 countries of the Commonwealth, and one of our main goals and driving forces and motivations is to uphold the rule of law. We also hold every 2 years a conference. In April 2019, it was in Livingstone, Zambia, and in September of 2021, it will be in the Bahamas, COVID and travel restrictions permitting. A previous conference was in Hyderabad, a city known to many of you, and I have to pay tribute to my immediate predecessor, Santan Krishnan, who largely organized the Hyderabad conference and who has promoted the CLA by his indefatigable traveling to perhaps 51 of the 54 Commonwealth jurisdictions during his presidency. I had ambitions to match, if not exceed, Santan, but COVID has introduced. But nonetheless, he's laid a great platform for awareness of the CLA throughout the Commonwealth. The conference in the Bahamas program was issued yesterday, and you will see that it has the theme Sustainable Justice. And I thought that was appropriate to mention on Human Rights Day, and I wish to take 2 or 3 aspects of the Universal Declaration and to relate that to sustainable justice in some way. Other projects that won't get mentioned by me are a project that we're starting on Indigenous land rights in certain of our Commonwealth jurisdictions, freedom of speech, and a project on child sexual exploitation. But let me take an obvious issue for the president of a practicing lawyers association, and that is the question of access to justice. Article 10, everyone is entitled to a fair and public hearing by an independent and impartial tribunal. And I just pose the question, do we feel that we have achieved that? Unfortunately, too many people that I have come across in my representative role find it difficult to agree that there is access to a fair and impartial tribunal. That may be because of corruption not properly tackled. It may be because of the manner of appointment of judges, and it may be because of the attitude towards the concept of an independent legal profession standing up for clients and challenging and holding to account those in authority. Only yesterday, I issued a statement condemning the intimidation of the judiciary in Hong Kong, asking that jurisdiction to abide by international standards, which are encapsulated in Article 10. In Eswatini, which you might know better as Swaziland, there are proposals to regulate the legal profession and appoint government appointees to deal with matters of admission, of training, of regulation, and of discipline. And I have said in other platforms that that seems to me to be creating not an independent profession, but a compliant profession. It is vital to the rule of law everywhere. The court system is accessible. And that means it is not just open to all, it operates efficiently, and it avoids delay, but it is also affordable. You have experience of the Indian system, and so I ask, do you feel you have access to justice? What about delays? What about the cost? Do you consider that your entitlement, your rights are decided when you go to court by a fair and impartial tribunal? Now, I'm only mentioning India because here we are speaking to friends in India and possibly beyond. But every country in the Commonwealth could have those same questions asked, and everyone would, I fear, be found wanting. And a lack of delivery of effective access to justice contributes to a lack of respect for the organs of the legal system, and where those are not respected, the rule of law will inevitably suffer. So how can we address that in our forthcoming conference theme of sustainable justice? Well, we can build upon the excellent work of lawyers and others. My experience of contributions to CLA webinars and, excuse me, to webinars that I've participated in across the Commonwealth is that people who are participating in events like this are the exemplars of wishing to contribute their time, their expertise, to share their experience, all with a view to upholding respect for the rule of law and for contributing to the debate of access to justice. The unexpected benefits of the pandemic has been the accelerated use of technology. We are able to speak to each other pretty flawlessly, and courts have adjusted to filing online, dealing with administrative matters through video links, and avoiding the unnecessary expense and delay of attending simply to get directions or to agree adjournments. That has been a legacy that I hope will be preserved in all of our justice systems. So I reflect on access to justice on Human Rights Day, but I remain concerned about intimidation of lawyers, intimidation of judges, and the cost. But I am also inspired by lawyers who contribute their time and expertise to uphold these principles. I should mention that there are alternatives to a court-based system of justice which can provide justice and more ready access, and that is through arbitration and mediation. And some of you may know that I'm particularly motivated by using mediation to resolve disputes in a way that meets the needs of parties, but which avoids much of the adversarial and the cost of a traditional court system. My second reflection is on Article 16, and in particular Article 16.2, which states that marriage shall be entered into only with the free and full consent of the intending spouses. The Commonwealth Lawyers Association published this, their tome, which is an assessment of the law relating to child marriage in every one of the Commonwealth jurisdictions. And Santan, who's already had an honourable mention, gives a wonderful message at the start and mentions that it is a tragedy, really, for child marriage to be and to remain so prevalent. The Commonwealth has a disproportionate number of the child marriages being child married under 16 years of age. And child marriage, the report says in one of its summary comments, leads to lower levels of education, health, economic status, and the social potential of girls. Premature sexual activity is akin to rape, and early childbearing. Higher maternal mortality and infant mortality are experienced, and there are serious health risks. And it also contributes to the perpetuation of illiteracy and poverty. And it does seem to me on International Human Rights Day, and reflecting the comments of Joytika, that child marriage, which is against the law in all Commonwealth jurisdictions, is so prevalent. And on Human Rights Day, could we perhaps commit ourselves to additional work in that regard, to upholding the law and to calling out this as something that the international community has stated very often is something to be deplored and discouraged, to put it mildly. So can we do more in that regard? The CLA would like to be associated, if possible, in continuing efforts to support that. Let me briefly mention that before concluding a third aspect, which is Article 7. And this says that everyone are equal before the law and are entitled to equal protection without any discrimination. And in the opening remarks, Tarun, you mentioned that India was a country of diversity and colour. Beth has mentioned her 4 priorities, and this includes the respect for and the living peaceably with a diverse community. I'm afraid that there is too much intolerance of diversity, and if the pandemic has taught us anything, it has taught us that we are one humanity, we are one human race. Scratch us and we all bleed, have a virus and it affects us all, and yet we are united by our humanity, but separated by our prejudice and our intolerance. And I would very much hope that on Human Rights Day, we remember the need to respect diversity, to support difference, and to rejoice in the bright colours and difference of religion, of views, of background, and of history and culture that makes being human so very engaging and worthwhile. It has been a privilege to share these very brief thoughts with you on those 3 aspects of the declaration. We repeat the warm greetings from the Commonwealth Lawyers Association. Please have a look, those of you that are interested, at our conference website. There's also a call for speakers, and I think I could identify some people from this webinar who could make a very helpful contribution to our conference. And the 3 matters that I leave you with are access to justice, upholding the laws relating to child marriage, and supporting tolerance and diversity. Thank you for your attention.
Thank you, Mr. Spears. That's indeed wonderful, and we're thankful for your message of 3-pronged approach of CLA's commitment towards furthering the cause of access to justice, and also for protection of children, and above all, fostering tolerance and diversity and respect for all kinds of thoughts and diverse ideologies and faiths and religious practices. Thank you so much. You leave us indeed with very foundational thoughts on the International Human Rights Day. Thank you. We now move forward, ladies and gentlemen, to the next speaker, Priya Hingorani, who is the senior advocate and also the president of Chevening Alumni India, somebody who has been behind steering the entire program together for quite a while now. So over to you, ma'am, and looking forward to your thoughts.
Thank you, Dr. Nachiketa. Again, a warm welcome from Chevening, India to all of you. A very good evening. And I would today like to say that I take this opportunity on the International Human Rights Day in this pandemic to celebrate the Constitution of our country, Constitution of India, which is one of the most dynamic, well-written constitutions that we have in the world. As you all know, our Constitution has guaranteed fundamental rights. I mean that our Article 32 is one of the most powerful articles of our Constitution, and it gives the right to move the Supreme Court to enforce the fundamental rights in itself. The rights are guaranteed in itself. So we have this, and as it is in most countries, but we have an article which has expanded over the years, has expanded its jurisdiction, its scope, and entertained so many more petitions under the Article 32 in the Supreme Court, which is beyond the traditional writs that we have outlined in the Constitution. When we talk of human rights, the words of Nelson Mandela come to my mind immediately, where he said, to deny people their human rights is to challenge their very humanity. And I think that's something which has stuck in the courts of India. And I find that the Supreme Court and the high courts across the country in India over the years has developed the new jurisprudence which was brought in India, known as the public interest litigation. And I must proudly say, and I'm blessed to say, that was initiated by my parents, in whose memory we have the foundation of the Nirmal and Kapila Hingorani Foundation. The first PIL, as we would say, the new jurisprudence which was brought in Indian courts was in 1979, when with the under trial prisoners case, where the thousands and thousands of prisoners were languishing in jails for longer than their sentence would have been, for petty crimes, for ticketless travel, pregnant women who had no place to go, women who had to depose in courts, but there were no short stay homes, they were locked up in jails. So it was one of those cases that which shook the conscience of the nation. And the Supreme Court, I must say, the Supreme Court in one order released 40,000 prisoners across the country and directed the jails in India to immediately act upon it. So we've had cases, whether it was Vishakha, which brought about the legislative changes. Vishakha was one case on the sexual harassment that we didn't have a law in place on sexual harassment at workplace. Under the decision of Vishakha by the Supreme Court, guidelines were laid down as to what is sexual harassment, the definition of sexual harassment at workplace, and how the rules and the regulations were to be put in place and were to be followed. And then we had the law which came in, the Sexual Harassment at Workplace Act came into being. We had another matter in the Supreme Court, which was on the mental patients, on the mentally ill patients, which was famously known as the Ranchi Mental Hospital case, where the court looked into the monitoring aspects and the administrative aspects and monitored the functioning of the mental hospital by appointing a committee, regulating it, and ensuring that the patients had good medical aid, got good food, were able to survive. Otherwise, there were cases that every day 2 patients were dying in that hospital. We had another very important case from the Supreme Court of Kamlesh, which was against rape dowry victims, where, as you all know, dowry has been a very prevalent evil in our society. And so pursuant to that case, the suggestions from the lawyers was that there must be more women's cells where speedy justice is given to the women in conflict, women who were suffering from dowry victims, dowry deaths or victims. And it was the monitoring women's cells came up in India, and they are functioning across the country in every state. So we've had those kind of cases which the courts, whether it was the Supreme Court and the high courts, who have actually proactively, with judicial activism, taken on and given excellent judgments and kind of redefined the roles, the new paradigm, the judicial reforms in our country. The features of public interest litigation, as I would say, because I'm emphasizing on that on Human Rights Day, would be some of the features were that it was remedial, it was non-adversarial, it was collaborative, and it was investigative. These were some of the features which are part of the which would be considered as the features of public interest litigation. It read new rights, expanded the scope in our country, and like for example, Article 19 of the Constitution, the right to to freedom of speech, Article 21, the right to live with dignity. And in fact, many constitutions across the world have kind of adopted the concept of public interest litigation in their judgments, in their laws. For example, South African has taken in so many, has referred to so many of the judgments of the Supreme Court of India. So I would say the courts in India have become one of the most powerful courts across the world, where they have actually taken justice to the doorsteps of the citizens. They have its justice at the doorstep, and to those disadvantaged sections of society who otherwise would never have an opportunity to come to the courts. While we, of course, laud the work done by the courts and the judicial reforms which have come through the courts, yes, we have also a lot of issues where constantly we are facing the violations of human rights across the country, whether it is with women and children, the disadvantaged section. Some of them have been mentioned by Jyotika, was mentioned by Brian, that the child marriage is one area where we really need to take a firm resolve to bring about change and to change the mindset in the country. Beth mentioned about the kind of work that they're doing across Western Maharashtra, and there's some of the issues which I have been actively involved with in this part of India as well. And I think it's important that the kind of work all of us are doing in webinars like this, in discussions like this, we get to know, we interact, we come across the ideas and it is a great forum to collaborate, to put forward, and to work together. So, and I think the idea of doing this event under the Chevening Alumni and with the foundation, of course, with the virtual law school, was because we have so much resource. I mean, we have the resource in the judiciary, like Justice Sachdeva. We have resources in the police, in the government, who can collaborate and work together to bring about social change, judicial change in the country. And we hope that, with these kind of events that we organize and we are interacting with, even whether virtually or even physically, we are able to not only commemorate the International Human Rights Day as we are doing today, year after year, but also carry forward the work that we all have started at our own levels in our own special way. So having said that, I would like to thank all of you, and also would like to conclude by saying that we look forward, and I would in a way like to celebrate and be very optimistic and take forward the good work that is being done across the world on human rights, and hope that we can make a better world to live in as we go along. Thank you.
Thank you, ma'am. Thank you, Ms. Hingorani. It was wonderful, truly coming from a Chevening scholar and a celebrated lawyer. It was a perfect blend of your, legal insights, having a deeply embedded thoughts from the empirical research that you've been putting into the filing of the public interest litigations, and with a very interesting and actual academic touch of, giving a lot of thoughts. I see it as a law professor that law students can think that how you've summarized the entire journey of the Supreme Court, expanding the frontiers of the fundamental rights and human rights. So some of my law students can definitely take a cue to, write a paper on several issues. Now, ladies and gentlemen, we move forward towards hearing from the chief guest for the program, for the International Human Rights Day program, which is being put together by Chevening Alumni India. We've heard from the lawyers, from law professors, and discourse on international human rights, of bringing diverse perspectives, even from Mr. Brian Spears. It's rather befitting that we now hear from Honorable Mr. Justice Sachdeva about his thoughts coming from his diverse experience as a lawyer, as well as his rich insights having served in the High Court of Delhi. Over to you, sir, and we look forward to your thoughts.
Thank you, Mr. Mittal, Miss Yates, and Mr. Spears. I have a special association with the British Council, the British government, and even Northern Ireland for that matter. As part of my training program, I had spent a week in Northern Ireland, in Belfast. This was in 1992, when there were different kind of atmosphere in Belfast, and I had actually gone and seen a trial which was held in the prison. There was a special courtroom created in the prison because of it's a high security trial which was happening. So I have special association and fond memories of England and Northern Ireland. And coming to the issue of human rights, but throughout human history, human rights as a concept is constantly evolving. These rights are associated with law, custom, religion from a very long time. And these rights are provided to people in a different way. In India, we have the Constitution. In UK, they are provided through precedents. But human rights are basic rights of freedom that all people are entitled to everywhere in the world. And they put responsibility on others not to violate the rights of other individuals. There can be several kinds of rights: economic, social, civil, political, cultural. Even recently, we've had a judgment of the Kerala High Court, and this is because of the visitor that we had recently. We just saw on the screen a visitor which was here on the screen, where during this pandemic lockdown, a petition was filed in Kerala High Court. And there was a complete lockdown and you needed a pass to travel. So somebody wanted to buy cat food. So he said, it is my fundamental right to own and keep a pet. And since I have to travel to get cat food, that should be granted as a permission. So the High Court held, yes, it is your fundamental right to own and have pets. So the permission was granted to travel even during lockdown to procure cat food for the cat. So this is on the lighter side. Priya mentioned about her mother. Well, when we were in college, we studied about the PIL concept, which was actually something which was developed by the Supreme Court, pioneered by her mother. And over the years, Indian courts have been looked at as one of the pioneer courts in terms of providing human rights facilities and recognizing human rights and securing and ensuring access to justice, as Mr. Spears mentioned. Now, India is actually a very peculiar country with peculiar kinds of problems. When the world faced lockdown, India also had lockdown, but the Indian courts adopted to technology and were, I don't think, shut for more than a week. And they're back with the use of technology, not only doing administrative matters, but all kinds of litigation is happening. Everything is virtually open. And daily we all judges sit and take about 50, 60 cases a day. So the courts, realizing that physical attendance of public could not be permitted in courts, adopted technology, and we've all functioning through courts, leading to, in fact, providing access to justice to several individuals. And over these last few months, why I'm talking of the last few months is because this is a time when everybody faced major issues. Under the garb of violating human rights, excesses could have been committed because access to justice was not available to individuals across the world. Everybody knew the courts are shut. You may not be able to access courts. So the Indian courts, especially the Indian courts, came up with the principle of waiving off the formalities which are there in terms of filing. So we would take an email or an SMS as a petition and register it and proceed on it. That's exactly what happened. We've done away with court fees because that was one of the major concerns. How are you going to buy court fees? How are you going to attest petitions? How are you going to sign petitions? So all an individual needed to do was call up his lawyer will draft a petition, formalities of the real system of drafting was done away with. A simple email was treated as a petition. We've had several cases. The very first thing that the Supreme Court did, in fact, on 23rd March 2020, when all this issue started, realizing that there was a lot of issue with regard to prisoners, immediately passed an order in suo motu writ petition number 1 with regard to overcrowding of prisons, and directed all states and union territories in the country to form high-powered committees to determine categories of prisoners who could be released on parole or bail. And in fact, thousands and thousands of prisoners across the country benefited from that order. In Delhi alone, I'm aware something like 5,000 to 6,000 prisoners were granted interim bail, parole, and with the orders now being passed, they are continuing on parole. This is for the reason of preventing spread of coronavirus in the prisons and ensuring that, because trial is not in a position, the courts are not in a position to conduct full-fledged trials, so prisoners would be languishing in jail without their cases being taken up. So this is one major step that the Supreme Court took up. Then the issue arose with regard to testing. Now, India being a country where everybody did not have access to medical aid, Supreme Court directed that in all cases, private labs and even public labs would provide free testing to eligible persons under the Ayushman Bharat Pradhan Mantri Jan Arogya Yojana scheme. Thousands and thousands of people were benefited from this. Without making any payment, they would just walk into a center and they would get their test done. Even for that matter, the Supreme Court also, in regard to foreigners detained in Assam, were directed to be released if they had completed 2 years in detention on furnishing a bond of a very nominal amount. And dozens of detainees were actually freed because of that. Then one major issue which we noticed in our country, which was probably not there in others, with regard to migrant laborers. The migrant laborers had to suddenly they got displaced, they had to go back to their respective states. Now they were having issues with regard to food, travel, accommodation. So Supreme Court again took suo motu cognizance of this issue and directed that no train fare or bus fare would be charged from them. The state governments were given the responsibility of footing the bill. They were transported back to their respective states. They were provided free food. Several states, in fact, several individuals across the city, I'm conscious of it, several individuals across the city volunteered and distributed free food to these migrant workers to ensure that their rights are not violated. They are provided with the basic necessities which are available. Then again, the issue arose with regard to children in protection homes. Again, directions were issued by this court to ensure that preventive measures were taken. Regular counseling was done of these children to ensure that there is no spread of virus. Then again, healthcare workers. The court again took no cognizance of the fact that healthcare workers are actually our corona warriors. They were the ones, their human rights were also at issue. They are providing healthcare, they are providing services selflessly to people who need it. So in that context also, the Supreme Court took cognizance and directed that they should be provided proper adequate facility. Even police security was provided to certain doctors, because we came across issues where doctors were prevented from coming back to their residences after attending to duties on the ground that they would bring in coronavirus. So for that, the court had to take cognizance and accordingly pass orders. Beds have been reserved in hospitals so that in case of a requirement, the certain hospitals have in fact been declared as corona hospitals or COVID hospitals to ensure that they would do away with all normal day-to-day operations and take care of only these patients who are coming from corona or suffering from corona. Bombay High Court in Rashtriya Shramik Aghadi's case came up with a novel principle, because what was happening was that workers industries were shut, businesses were shut, workers were not being given any work. So the owners were coming up with the principle of no work, no pay. That since you are not working, so we will not pay you. To which the High Court of Bombay ruled that the workers are willing to work and offering their services. It's the owners who are not in a position to run their industry and take work. So that concept of no work, no play was also kept aside, and they were directed to provide full wages and food, except food and conveyance allowance, which was not being spent. They were directed to pay full wages to these individuals. Apart from Corona, we've had recently the issue of access to internet and free speech in the state of Jammu, in now the Union territories of Jammu, Kashmir and Ladakh, where the issue was connectivity. So the court ruled that the constitutional protection under 19.1A and 19.1G also enjoins the right to access to internet and free speech. We've had the case of Permanent Commission for Female Armed Forces Officers, where the Supreme Court ruled that female officers would be treated at par with men and provided permanent commission in the armed forces. Apart from that, we've had several issues where this country, the judiciary, has risen to the needs of the people, providing human rights. And like I said in the beginning, there have been major issues because we have a unique culture, unique system, but the courts in this country, I'm happy to say and happy to be part of it, have been alive to the situation, alive to the difficulties which could have arisen if access to justice had not been available. So novel way was found, and I'm very happy to say that Indian courts were functioning even prior to most of the courts in Western countries. So Indian courts were operational even today. Some of the courts in Western countries are only doing administrative matters and minor cases are being taken up. But the Indian courts are fully functional, except for some major issues where public is required or where individual has to actually travel to court. Everything else is operational. Mr. Spears mentioned about mediation as one of his favorite topics. Delhi High Court has one of the best mediation centers in the country. And in view of the lockdown, we've started online mediations. So parties do not have to travel to the mediation center. They are connected over VC and their agreements are also signed and confirmed over email. So nobody has to actually go into court, and the moment it is filed in court, the parties are connected over VC and we accept them and rule on them. In fact, today I had 2 cases where mediation settlement had come and the petitions were disposed of. Because as Mr. Spears said, mediation is close to his heart, so it is close to my heart. Because mediation not only finishes one litigation, it in fact finishes several litigations and both parties go back with a full win-win situation. So those were some thoughts that I wanted to share with all of you. Over to the organizers for the future question answer sessions. Thank you very much.
Thank you, sir. Thank you for giving us a very detailed summary of how in an very unprecedented manner and in an extraordinary method and ways, how the Indian judiciary, the Supreme Court and all the high courts across the country have taken up this entire discourse on human rights forward, especially during the challenging times of pandemic and COVID, and more specifically during the national lockdown in the country, ranging from diverse issues of taking care of migrant laborers issues, healthcare professionals, lawyers as well. I was reading the judgments also coming from your bench in earlier November, last month, how proactively even your bench, has clearly specified that the lawyer should not be made compulsory to appear in physical ways in the trial courts. So there have been different kinds of methods and approaches the Indian judiciary has been proactively taking note of, so that the human rights are duly protected in the unprecedented times, so that we all can remain safe. Thank you for the elaborate mention of all of those, sir. Now, with permission of all our panelist speakers here, my dear friends, In the audience, I have sent the message while Honorable Justice Sachdeva was speaking that if you have certain questions for our speakers to take up, we'll be happy to unmute you, or if you can quickly type your questions in the chat box or Q&A section so I can read it out on your behalf. So there could be certain difficulties at your end if you're not able to use the microphones, but we can definitely read over the questions on your behalf. So let's take a 30 seconds pause there. And although I've just mentioned that in, so if there are any questions, we can then quickly route it to the specific speakers.
If I can say, I was just going to endorse what Justice Sachdeva has said about the Indian courts remaining open and active, and it has been a tremendous achievement, and certainly in the Commonwealth context, India, yes, can rightly be proud of the initiatives and the use of technology and the flexibility and imagination it has provided in terms of access to justice. It is funny that every jurisdiction has these little cases about your right to buy pet food and things like that. They're all indicative of a functioning court system and a recognition of taking issues seriously. So I very much enjoyed the judge's comments, and particularly as he really is at heart a Belfast boy.
Yes, I mean, I agree. And I think the way the mediation, in fact, now the way, unfortunately in India, we don't have the mediation law in place, but despite that, the way the courts have evolved the mediation process in the courts, and the training, the extensive training that is taking place with lawyers and with litigants, it is commendable how without an act being in place, but by procedure and guidelines, the courts have evolved a mediation system, and which is working very well, whether it is in commercial disputes or family disputes. And the lawyer's mindset is also changing to accept mediation as a well-paying branch of litigation.
In fact, in commercial disputes, now pre-litigation mediation has been made mandatory.
Yes.
So under the Commercial Courts Act, unless it's an urgent case, the party cannot file a suit unless he's given the option of pre-litigation mediation. And now most of the people are, even in matrimonial matters, choosing the method of pre-litigation mediation rather than going into court, spending a lot of money and coming forward. For example, in the Delhi High Court Mediation Center, they have to register their request, pay a nominal amount for pre-litigation mediation. If the mediation is successful, the money is kept by the center. If it is unsuccessful, the money is returned to the parties. So in that sense, it is sort of promoting mediation in a major way.
Right. So if I may add, for everybody's knowledge, I'm sure some of my Indian colleagues and lawyers would know, but Mr. Spears, you will also be happy to note that earlier this year in August 2020, the Bar Council of India has come up with a circular making the course on mediation compulsory for across all law colleges in India as a separate course. Earlier, it was taught as a part and parcel of the course on alternative dispute resolution. But I guess, and I believe so, that given as Honorable Justice Sachdeva has mentioned, and Senior Counsel Priya Hingorani has mentioned, and you yourself have highlighted the significance of mediation. So even the Bar Council has probably thought of it in a proactive way to make a course on mediation compulsory for the upcoming lawyers across law schools to study that in a very professional manner.
That sounds absolutely fantastic. The next generation of lawyers will have a mediation string to their bow. The use of online technology for mediation has been quite a revelation as well. And only last week, I conducted a mediation with parties here in Northern Ireland, in Germany, and in Australia. And it was, the organizational effort that would otherwise have been required was achieved really very successfully with online. So yes, the CLA stands ready to contribute guest lecturers and contributions to any online mediation training, and we've already been involved in some of the Supreme Court mediators webinars that have taken place. So interesting that we've managed to divert ourselves onto mediation.
Right. Thank you so much, sir. That's really thought on that line. In fact, to brief everybody in the audience and also to my respected distinguished speakers and panelists here, that is part of my efforts being a legal academic person. So, along with the Alliance Law Office and Dr. Aman Hingorani and Ms. Reema Bhandari, who are two trainers on mediation from the Supreme Court, the Virtual Law School, in partnership with the Gujarat National Law University and National Law University Odisha, is going to conduct the first of its kind training exclusively for the law teachers on mediation, in keeping with the Bar Council circular, so that the law teachers also have a very professional approach towards teaching of mediation, because probably some of you may agree that as part of the ADR courses in India, we largely get into teaching of the arbitration law, which is codified, but the mediation sometimes takes a back seat. So we're trying to change that discourse and do our bit in that context. And the Supreme Court has agreed to inaugurate that particular training program for the law teachers. Mr. Spears will be happy to look forward to your support in that regard as well.
Dr.
Thank you, everyone.
I think
Yeah.
there's a question. There are some questions in the chat box, I think.
Okay, let's quickly take them up. Okay, maybe they're not routed to me. Might have been, ma'am, privately routed to you as well.
No, I think it's one question for Justice Sachdeva.
Okay, yeah. So because it's not been routed to me directly.
Maybe Priyaji, you can read the question.
Yeah. No, I've just got a message that they've asked a question for Justice Sachdeva. I don't have the question with me.
Has it gone directly to Justice Saab?
Sorry, you may want to check if it's directly been routed to you, because there's a facility of directly making a question, routed to the speaker as such.
If you see right bottom of your panel where you have participants, on the right bottom you'll find a Q&A.
Right.
So switch off the panels, and at the right bottom where you have chat, there's a balloon with participants and chat.
Yes, sir, but in the Q&A, as I'm not able to see any question out there. So probably I wanted to check in the chat section as well, which again doesn't appear to be showcasing a question open for everyone to read. That's why I was.
There are three dots on the right.
Right.
Click on that. You'll find the Q&A.
Yeah, I did that, but in the Q&A section, I was not able to read the question as such.
But I was going to ask a question to Brian, if I may. Brian, when you're talking of substantive justice as part of the program for Bahamas for your next conference, are you looking at having something with the broad theme is substantive justice, but are you looking at programs or topics relating to the pandemic and how the world over, the countries have managed, the Commonwealth countries have managed the legal systems in the pandemic?
Thank you, Priya. Yes, it was sustainable justice, the theme, and so it will include access to justice. It will include lessons from the pandemic. On Human Rights Day, it's worth mentioning some concern about the use of emergency legislation in countries, which really should be time limited and only for the duration of the emergency. But some governments like the thought of just ruling without much consultation with their parliament, and it becomes a very, I suppose, straightforward way of getting decisions through. And democracy, believe it or not, can be a little bit of a nuisance and hindrance, but we don't want people to fall into the habit of governing by decree within an emergency. So that will feature, but sustainability is also within the environment, and there will be interesting sessions on the right to a safe environment, the obligations of industry and governments to address climate change imperatives and to cease pollution. So sustainability is part of the theme, and there will be sustainable legal topics and also sustainable environmental topics.
Thank you.
Right. We do have one question coming up now in the chat box, if I can route it. That while the courts in India strive incessantly to deliver justice, large number of cases vis-a-vis limited number of judges, delays in appointments, etc., necessitate the right to speedy justice is acknowledged as a human rights. Any thoughts on that? So it's an open question, not routed to anybody in particular. So it's basically, seeking some thoughts on how the justice delivery can be accelerated with regard to the issue of delays in appointments and limited judges for per million population.
We'll let Justice Sachdeva answer that.
Sure.
Well, I don't think I'm yet in the position to answer that question, but of course, delay in appointment does affect the delay in disposal. But people who are not part of the system or who have not been part of this side don't know that what is the process or what is the effort which goes in appointing one person. Is not like appointing a particular individual to a post in a service. It's a constitutional appointment, and a lot of thought process and let me put it like this, research goes into before somebody can be appointed to that position. So, and the concerned are actually working on it, but of course it does take time. The appropriate individuals, probably in correct forum, might be able to answer this question better.
Right. Thank you so much, sir. Indeed, Mr. Desai, when you asked the question, I'm sure you might now be able to understand that it's a very complex issue in itself, and there cannot be, open and shut sort of an answer to that. But just as Sachdeva has certainly put it through, that it's a issue which does touch upon the issue of speedy justice, but there's larger debate into it, which probably would be, dealt with at appropriate forum. So thank you, ladies and gentlemen, and I now, with permission of everybody, would request Dr. Sachin Bajaj to deliver a formal vote of thanks and for the program. Over to you, sir.
It's been a wonderful 1.5 hours. I don't know how those 90 minutes passed. I've been spellbound by the quality of conversations and addresses here. So thank you very much to all our honorable speakers, Honorable Justice Sanjeev Sachdeva ji, Mr. Brian Spears, Srimati Jyotika Kalra ji, Beth Yates, our own Priya Hingorani ji, and last but not the least, of course, Nachiketa ji for moderating the session so well. Very big thanks to all the office bearers and members of Chevening Alumni India who've played a big part in getting this event together and online, especially our president, Ms. Priya Hingorani, Vice President Tarun Singhal ji, Treasurer Amita Dugal ji, Joint Secretary Nirmal Mathur, and all the members of the Executive Council. A very big thanks to Kapila and Nirmal Hingorani Foundation as well for supporting this initiative. And a big thanks to Virtual Law School for participating and collaborating in this big venture. Many thanks to all of you for attending and giving your questions and your precious time to this address on this very important day that we are celebrating today. We look forward to seeing you again. Chevening Alumni India will be organizing more such events in the future, and we look forward to having you over in our next events as well. Thank you once again.
Yeah. Thank you, everyone. And before we take a leave, I would just make a mention that the recording of today's program will shortly be available on the YouTube channels and the Facebook and other social media accounts of Chevening Alumni India, Kapila and Nirmal Hingorani Foundation Virtual Law School. So please do watch that. Some of your friends who might have missed out, there's a lot of takeaway from today's session. Thank you, all ladies and gentlemen.
Thank you. Thank you, everyone. Thank you, Brian. A big thank you to Mr. Santanam Krishnan for putting us all together. Thank you. He's there.
Thank you.
Yeah, thank you. Thank you, Sachin. Bye.
Goodbye to you all. Bye-bye.
Thanks all. Bye. Bye.
Bye-bye.